Well, good morning. It's almost lunch. My name is Daniel Ellis. I'm a local attorney in the Knoxville Bar. My colleague, Professor Joy Redis of the University of Tennessee College of Law. She runs the Expungement Clinic. We are both co-chairs of the KBA Access to Justice's Expungement Subcommittee. And today we're going to focus first on a real quick discussion of what expungement is and how this fits into society and why it's important for individuals. And then we're going to dive into the statute that changes every year, and give you the best understanding we can in 45 minutes.
So picking up where Daniel left off, anything you know right now for expungement is good until July 1st. Then it all changes. No, but there are some really excellent bills that will help people expunge even more things, expunge them cheaper, that are now being introduced, that are now being considered. So on July 1st, take a look for any of there are incremental changes, but the changes you'll want to know about to advise clients. The proliferation of the criminal record. Criminal records are more accessible today than they have ever been. The internet has increased their ability to be picked up and received for very little, right? If you search, one of the things I like to do is search criminal records, you'll get hundreds of responses of databases that purport to be able to give you anything from who I'm married to. When I do this with students, I put my name in, they find out when I was married, they find out when I was born, they find out how many kids I will have, but one of the things they will also, if they pay a small fee, find out is if I have a criminal record. And so in terms of who is affected by the proliferation of criminal records, somebody with a criminal record in so many areas of their life, people are looking for it. I've had students say to me, I use these databases when I'm looking at somebody who I want to date. I've had people tell me, when I hire a babysitter, of course I'm going to use one of these databases. And so in terms of just starting you off to think about, why are we even talking about expungement? Why is it important? It's because for our clients who have criminal records, people are going to find out about it, and helping them figure out how they deal with that, how they address it in a job interview, in a housing application. And given that Tennessee has an expungement statute, how they might reduce their criminal record is really important. And so we hope that the time we spend with you today will give you the steps, the tools that you need to take the steps for your client to minimize what their criminal record looks like, so that when they're trying to get a job, they can have the greatest opportunity possible. The other reason why it's important, which we really wanted to point out, and so we're going to take like a brief pause to make this point, is that actual state statutes impede people with criminal records from doing certain things. I mentioned housing. Certain federal housing regulations make it harder if you have specific convictions, or in some cases, if you have a conviction at all. In addition to federal statutes, if you have certain types of drug offenses, getting into college is going to be more difficult. Getting financial aid is going to be impossible. And so thinking about how state statutes themselves affect our clients, I think, is something that's worth thinking about. So it's not just about private landlords and private employers, it's also about actual state and federal statutes that create obstacles for people with criminal convictions. And one of the biggest areas that you'll find this, which I'm sure if I asked you, what would you think it would be, it's in getting employment licenses. So anywhere from a security guard license, which the state endorses, it has to give you for you to be a security guard, to a real estate license, having a conviction on your record can either make it harder or actually impossible to get that state license. My favorite client was a man who spent 12 years in prison for an aggravated assault, where he became the facilities, and this was a facility in New York, so it had thousands and thousands of inmates. He was the head barber in that facility, and when he got out, New York State refused to give him a barber's license because of his assault conviction. And so it begs the question of how these things make sense in the long term, right? The one thing we trained him to do well, that he loved and he had as a craft, we weren't going to allow him to do. And so what do we expect will happen? And his story was enormously tragic. Different states have different numbers of these statutes. And as you're thinking about the front end in terms of how to advise clients about them, there is an incredible resource that we wanted to make sure that you knew about. And that the ABA spent years pulling together. So when we asked states, how many collateral consequences do you have of convictions? How many statutes do you have? States didn't know. The reason they didn't know is during the 80s, these types of collateral consequences would get tucked into bills and added, and no one was really paying attention to them accumulating. That's how you end up with 800 or 1,000 of them. So the ABA took on a huge, massive task that they funded to actually force states to look for them and to categorize them. And so through this website, you can, and this is Tennessee's version, you can actually see what collateral consequences attach to certain convictions. So if you have a client that you're advising to take a plea to a simple assault or a kidnapping charge, you can actually look up that statute on this website and see how many things are going to be permanently barred for him, and also how many things would be potentially barred for them. And so some of these things automatically attach. You have this felony, you're not going to be able to do X, Y, or Z. Some of them are discretionary, and those are the trickiest because you might have the client might have a hearing about it, they might be afforded an opportunity to make an argument, but most of our clients don't know that when they're taking pleas, and they don't know exactly the types of civil barriers that they're going to face once they have these convictions. And so I just wanted to make sure that you had the website, that you know where it is, and I would just play around with it. Put in any statute, any criminal code, drunk driving, assault, influencing a minor with drugs, and it will then spring up all of the different things in the other portions of the code that create civil barriers. And it's really eye-opening. I mean, it's an incredible thing when you see 30, 60, 200 things come up and attach to a certain conviction. The other thing that many of you might confront when you're dealing with expunging people's records is, why should we expunge it? So Tennessee actually has a statute that allows you to expunge certain things, but there are still prosecutors and judges who you have to talk to about expunging certain records. And one of the things that we wanted to give you was just a little bit of information about why we might even consider doing this. I had one of the General Sessions judges say, I gave this guy this conviction. Why on earth would I want to remove it? Well, one really easy answer is the statute says you have to. Okay, that is an easy answer. But I want to go a little deeper with skeptics because I really want them to think hard about why we'd want them to. Part of the answer is what we were talking about. There are all of these things throughout the rest of their life that are positive things that we want them to potentially do. Vote, serve on a jury, get a job. And those are things that if we create barriers to them, where are they going to end up? Back in the system. And so that's part of the argument that I try to use when I'm talking to folks about why expungement. But the other part is actually scientific, and people seem to like science more than they just like legal policy arguments. And there have been decades and decades of criminology research on theories of desistance. Desistance is when you stop committing a crime. And so criminologists have taken a look at what causes people to stop committing crimes. And there's several different strands of these theories, but one of the most prominent, I found a chart like this from the 1800s in France. One of the most prominent things that stop people from committing crime, what do you think? Age. Age, right? Our brain develops, we become more mature, we become better decision makers, we get married, we have kids, we do things that tie us to things in our life that make us want to go straight, get our act together, and live a more lawful life. And so one of the things that the criminologist has found over and over again is that age, specifically late 20s, 30, is a huge drop-off period for committing crimes. And so in terms of people who are more risk adverse and nervous about criminal convictions, age matters. And so do other environmental factors like marriage and kids and building your resume, going to college, things that create stability in your life. Criminologists have shown make people stop committing crime. Not brain science, but it is real science, and it's real science that can help convince somebody who might be skeptical about hiring somebody or giving somebody an apartment for rent that could help convince them. The other main statistic that I would throw out to you is that over and over again, criminologists have shown that anywhere between 5 and 7 years, a person with a conviction is no less likely to commit a crime than somebody without a conviction. And so sometimes you hear that 7-year mark, like let's expunge after 7 years, let's expunge after 5 years. That's coming from decades of criminologist studies that show that for very different types of crimes, they've done them for burglary, robbery, aggravated assault, very different types of crimes, the same crime curve comes up over and over again, which is that after a period of clean activity, no new offenses, no new arrests, people stop committing crimes. And in fact, hiring somebody without a conviction is not going to be any more likely to indicate to you that they're not going to commit a crime than somebody with 5 to 7 years of crime-free years. Does that make sense? So, just a little bit of more, I want you to feel like you really were in law school today.
All right. So, to continue that vein of inquiry, talking about pervasive disenfranchisement, what is the goal of our prison industrial system, or the Tennessee Department of Corrections? Well, their mission statement, as you can see, is to operate a safe and secure prison to enhance public safety in Tennessee through the incarceration and rehabilitation of felony offenders. So what an expungement can mean for an individual is an opportunity for a better life for themselves, their children, and their families. So people who would be potentially interested in expungements are not always just the individual. Often it is the parent, it is the sister, it is the brother, it's the grandparent who's seeing someone who's just out of jail and there is a chance to get them on the right track. Well, talking to someone early about expungement can be a good way to say, this is how we're building towards something. Of course, it takes years to do. So just to touch base briefly, the 7-year period that Joy is talking about is very pervasive. And security clearance applications, your SF-86 form, they usually ask, in the last 7 years, has this occurred? In the last 7 years, has this occurred? So in terms of employment, in terms of opportunities, there's a lot, the science, people really buy into this. So let's go to the next slide. There we go. What are expungements? Expungements are the process by which all public records of a criminal charge or conviction or arrest are removed. The most important thing here, you can read this slide 5 times and miss it, public record. The private records of the district attorney's office are their private records. And expungement in the state of Tennessee does not require the DA to destroy those records. They can be kept and used for the purposes of enhancing an offense or several other purposes which we'll discuss later. One other thing that's important about collateral consequences is negotiating with the DA. If you're doing any kind of criminal case and you're talking about a potential plea bargain and you're looking at the specific consequences of crime, but you need another tool in your toolkit in terms of interacting with the DA, the ADA Collateral Consequences website is a great toolkit to show why I don't want this charge because it's going to hurt my client who wants to go to school for this or has experience in this. And that would be another way to use the material we're giving you today. So I'm going to turn it back over to Joy. We're going to talk about Tennessee's expungement statute.
The statute. I handed it out because we're going to use it. And we're going to, okay, first of all, I wanted to hand it out. Did you expect it to be this big? I mean, this is ridiculous. This statute is a mess, and if there's anything I hope my mini clinic can help do is make it a little bit easier and more user-friendly. So the first thing we want to start by saying is that this is not easy to read, and I encourage you to read through it because we are not going to be able to go through all 18 pages of it today. But we're going to hit the highlights and encourage you to do more than that. But it's convoluted. One of the things that my students say that I loved Expungement Clinic because I realized how hard it is to understand a statute. And it's a really great example of that. And for the students, they say, then how do you explain that to a client? It's even more difficult. So what are we going to do? Let's look at some of the major pieces of 4032-101. We're going to look at little a. Little a. Little a has 1, 2, 3, 4, 5, 6 sections, one of which is deleted. So we don't have to worry about C. But besides C, let's figure out what at least little a is doing. And how are we going to do that? Well, I'm going to put you to work. I'm going to ask this group to look at little A1, capital A. I'm going to ask you what it says. I'm going to ask, starting with, I don't know your name, I can't see your name, in the black. Everybody to this side of the ladies in the black are going to look at A1, B, capital B. Everybody next to our ladies in the black are going to look at A1 capital D. And then half of you guys, I'm going to give you E. And then the other half, I'm going to give you guys F. Okay?
Oh.
I'm
I
failing
never made
you.
F before.
You're not going to either. I know who I'm calling on for F. So just take a look, and I want you to be able to summarize that section that I assigned you in a sentence to the group. And once you finish that, move on to the other parts of it. You have to stop with your assigned section, as I tell my students all the time. But I'm literally giving you 60 seconds. All right, I hear people talking. Whenever I hear that in class, I say, you figured it out and you want me to call on you. A1, capital A. Who wants to help me over here? It's one of the big, everybody look at it while we're going over it. It's one of the largest, like, textually parts of the statute, of this part of the statute. What does it tell us? What can we expunge?
Arrest.
You can expunge arrests. What kind? That
do not result in conviction.
that get no conviction status. So they can be dismissed. Are there other words that might appear on our Jim's report other than dismissal? No bill, no lacrosse, right? So anything that does not have a conviction that happens to you has to be petitioned for to be expunged. One of the most shocking things when I moved to Tennessee was when I saw criminal records that had dismissals from the last 20 years. I don't understand till this day why they're not automatically expunged if they're dismissed, but they're not. And so if there's one thing you could also do for your clients when you get that dismissal is expunge it right away. Anything else that we're missing in A1 capital A that my crew here wants to talk about? A lot of text, but comes down to a pretty easy summary. B, what do I got going on in B?
Successful diversion completion.
Successful diversion completion. So in B, if you get something diverted and it says on Jim, on your criminal history, diversion, you can get it expunged. There's going to be more to say about that, but right now,
Well,
You still gotta pay.
you still got to, all right, let's jump the gun. How much?
Well, the courts, what it says, the courts be under 28, 24.
So it tells you where to go, but there's a fee under this statute of, John, $350 from the statute. But what you just said, don't write that down yet, because different jurisdictions, this number is different.
$100, Knox County.
Depending on what jurisdiction you are in, the statute was recently amended, yay, to say clerk's offices can add an additional fee for the cost of, I guess, pressing the delete button. I know that's really sarcastic, but like, come on. How much did they add?
$100.
$100. Are we, oh wait, oh no, sorry, go ahead.
Add 125.
So John does this.
475.
I'm going to introduce John Baxter now. He is a 3L here that knows more about expungement than any other human being in Tennessee. He is down in General Sessions Court twice a week expunging pro se records. And so the number, I've only been in Knoxville for 4 years, and it has changed at least 10 times since. And now it is up to,
475 for a diversion.
and then you
450
want,
for a conviction.
do it again?
450 for a conviction. So $25 discount for a conviction.
Is that intuitive to anyone, that it's actually cheaper to expunge a diversion than, yeah, okay. As
It's
long as it's not
also-
just me.
It's also a pretrial, not judicial.
So talk to me about that though. What does that mean?
They want to argue with you that you don't really have a pretrial diversion that qualifies under this if you have actually signed and gone on post-trial. If you have a quote, you've signed to be convicted unless you complete this, and when you complete it, they say, well, but it's post-judgment.
So there's different types of diversions under Tennessee law. Pre-trial, you basically agree to it, and then the diversion enters once you complete it, but no conviction enters onto your record. Judicial diversion, is actually something that enters as a conviction if you don't succeed at it. And so your big problem with judicial diversion is that the diversion only enters after you complete it. But you are telling me that you've had problems places getting even judicial diversions expunged?
I haven't done one in years, so that used to be a problem. I don't know if
So-
it still is.
In Knox County, they are expunging judicial diversions for the
But-
same $475 fee.
What we're telling you today, so here's my 10th disclaimer, is that we know Knox County really well. We get calls every day on our hotline for other counties, and we are scared to take them yet because every single county has different interpretation of what is a really toughly written statute. I'm remembering now that I'm being video recorded. A statute I would like to improve over time. But so there are, so the reason we're saying DAs and judges, right, is that the statute goes to the DAs and the clerk's office, the petition goes to the DAs and the clerk's office first. They sign off on it, and then it goes to a judge to be signed. All of this happens without you there. You can, if there's a disagreement at any point in the way, there could be a hearing, but you have to request it. There could be a hearing that you have in front of a judge to actually make some of these arguments. But for the most part, what we're seeing is that advocates, attorneys are making these arguments to DAs and judges more informally. And so this makes it a really, a different kind of, adversary process than we're traditionally used to. Anything else? Okay. Anything else on so diversions, I think, I would wholeheartedly argue that it applies to all diversions, but I also like to ask this, if you start hearing different types of things, I handed out my business card, please let us know, because the more we hear about differences, I mean, the legislature really does look at the statute. That's the good news. And the more we can use evidence of, they don't like for different jurisdictions to be doing different things. So to the extent that they meant something that's not super clear in the statute, we might be able to improve on it. All right, so wait, we're up to, oh, D. D's kind of easy. Was this assigned D? What did you have for D?
That unless it's a sexual offense defined under one of those two statutes.
So just be careful. There's some things that are excluded. Look at D. Sex offenses we don't like, and so we're not going to expunge them even under circumstances of diversion. And so you definitely want to take a look at the statute carefully because there are exceptions written into it, and I like to go over D to show you that. E. What do we have for E?
Well, I guess except as provided in subsection J, which I didn't read, you would be entitled to expungement unless.
So then there's all these unlesses, right? So now you're like, yes, this record could be expunged. But if you don't read this section, you might be wrong.
Right, so if you have a charge, but you're not convicted of that charge, but you are convicted of a lesser included offense or another offense that's included on the same charging indictment or from the same facts arising out of that indictment, then you don't get an expungement.
What an awesome little paragraph. What does that mean in plain English? What is that talking about? Is anybody looking at that saying like,
This seems like
Maybe.
it takes out a lot of things.
It takes out a lot. What types of things? So first of all, non-movie, there's something with driving offenses that's excluded here. And there's another part of the statute that so if you have, another shocking thing about Tennessee is you can get a conviction for more traffic offenses than I'm used to. So you can end up with a basic misdemeanor for speeding, for different traffic offenses. So we're going to tell you later that the only time you can expunge a conviction, so all that we're talking about now are non-convictions. So this whole beginning part of the statute talks predominantly about non-convictions that can be expunged. When you go toward convictions, oh, we're going to have even more fun. But when you go to convictions, you can only have one, and you can only expunge one, and it can be the only one on your record, right? So how many of our clients are those? So that's really important, except for traffic offenses. Traffic offenses would not be counted against you for that one conviction rule. That's the first thing to be aware of. John, if you had to explain this section in plain English, how would you do it?
Essentially, the example I usually give is if you get arrested for simple possession and possession of paraphernalia.
Would you come a little
Yeah,
closer?
sure.
Thank you.
Arrested for simple possession and possession of paraphernalia, you dismiss the possession of the simple possession charge and only get arrested or convicted of the possession of paraphernalia. Even though the simple possession was dismissed, you can't get that dismissal expunged because it was an included offense with the two that were indicted together. So it's dismissed, but it stays on your record showing the name of the charge, and it says dismissed to the side. Except last year they added subsection J, which is at the very end of the entire statute.
Please go to page 18. This is the example of why you have to read the whole thing, and you have to know the whole thing to really understand Expungement. So then what happened in J when they amended it in July 2015 is they said that you can get dismissed charges connected to convictions. So when I got here in Tennessee, you could get the dismissals attached to a conviction expunged. And that's for people who care about people getting jobs and housing and all that good stuff. It's important, right? Because I'm charged with assault, but I take a plea to trespass. I like the trespass. That doesn't look as horrible as the assault, right? Especially if I'm an employer. So if the assault gets dismissed, I can take that off. The law changed while I was here that said no, and that's where you get E that we were just looking at. No, you can't take those dismissals off. We want to see everything connected to a conviction. What we then assumed is some legislator's child or relative had to then not get something expunged that was dismissed, and they said, oh, the earlier version was better. And I really do think something like this happened. Like they realized how important getting dismissals off a record would be, even if they were connected to a conviction. And so instead of rewriting E, which is probably what I would have done, they tacked on J, and J is allowing you to do that. Does that make sense? Is everybody, are we all following so far? Because I'm trying to confuse you, no? All right, and then what does our last section do?
Our last section gives us an acquittal, gives us the possibility of expungement if there's an acquittal by judge or jury. And it's upon the judge after the acquittal to raise up the issue.
That's right. That's an important part. So basically it's another way a dismissal comes off your record after an acquittal, but that part of the statute actually requires the judge to tell you that and to do it, right? Which is a little bit different. All of the other things we've talked about so far, the attorney or the person themselves have to figure out how to file a petition to get these dismissals or non-convictions removed. After an acquittal, you have the statute's doing something different, which I just think is interesting to point out so that you know about it, but it should happen, and I've seen it happen.
Also, that means that you should be adding the e-motion practice in the courts that you're going to try a criminal case, a motion for the judge
To remind them?
to do this upon acquittal.
Yep. Yes, ma'am. That's a great idea.
And can I have my pen for my earlier answer, please?
You're slacking on our toe here.
It's a tire gauge.
Thank you.
So, Daniel told you what's expunged. Are you know what's expunged?
Sure, yeah. All right, so we talked again. What is expunged, what's not expunged? Public records are not expunged. What the DA has on file confidentially, they get to keep. But one other important element to this is that the district attorney's office is not the only people in government who get to keep their confidential records on file. Another agency that's specifically mentioned in our next slide here, and we put this up here to just show how much of your public record is not, how much of your records are not expunged. Records with the Department of Children's Services or Department of Human Services are a key sticking point that a lot of people don't know about. One thing the Department of Children's Services has for the protection of children is an indicated list. That is someone who has indicated that they might have perpetrated child abuse in any way, shape, or form. This standard is very low. Once you're on that list, you can apply to get off that list, but you've got to do it quickly. There are some attorneys that are adding this as an area of their practice. There are several attorneys in Chattanooga that are having a lot of success getting these overturned. But your public record can follow you in many places. Another non-specific to the statute, but way that you can advocate for your clients that I have seen done on one of my cases actually, was an individual had a criminal charge 6, 8 years ago. They pled guilty, were placed on a diversion, and then it was, of course, expunged. Now, you Google this person's name, what comes up? A newspaper article covering that charge. Well, free press, they don't have to, they can keep it on there as long as they want. But if you want to use your skills as an advocate and as an attorney to write a polite letter informing the newspaper that it would be of great benefit to your client who has progressed, life has changed, they are rehabilitated in their future career, and this is no longer a newsworthy topic. This isn't a crucial point in history. This is one person in a small town where this happened. Could you take this off your website? And I've seen if the letter's politely worded, that'd be accomplished. So in working with your clients, there are a whole host of other issues that the statute, that our expungement statute does not really address. Just busted. Has anybody seen Just Busted? There we go. Yeah, several people. I had a client that was charged with a false report, which in the caption for the statute also includes the phrase, or then did bomb threat. So my client got woken up at his home. Is your father home? No, I don't think so. Well, his dad went in through the other door. So he wakes up Monday morning with a bomb threat charge advertised to all of his neighbors. Not something you can get expunged. So, I think I'm passing it back over to you. Let me see what our next slide is. We have a question. I guess I can ask this question. What happens if you release a expunged record? A record has been lawfully expunged, but you work at the clerk's office and somebody, they provide that expunged information.
Daniel was nice and gave me what part of the statute to look at. When I give my students, I make them just sit there looking through it.
That's a look, it's not.
No? Was that a no?
Yeah, that's
Nothing?
a no.
Nothing.
You don't have to look,
No
you
big
know
deal.
this way it's gonna work.
Well, if you look at the statute, there is, in fact, a fine that can be assessed against the person. It is a Class A misdemeanor, is that correct? So, though in fact, sometimes nothing happens,
That's
there
right.
is a provision in the law to enforce it. So, and then of course, how do you prove it? How do you find it? That's the problem. So, let me pass it back over to you. Oh, actually, this is mine as well. So, Joy did a great job of challenging you, of showing you to dig into the statute. It's not as scary as it looks. And she did a great job of having people actually look at the different sections. But just for kind of the benefit of our time here today, I'm going to kind of go over these sections generally. The section that we already went through, 4032-101B, covers public records. C covers penalties for disclosing information. And 4032-101D covers processing costs. Now, we've already talked about that some, about how it varies, sometimes varies from county to county. One county it might be $100, it might be $125. In the next county it might be different for diversion, it might be different for other things. Another important thing that you need to do when you're doing an intake on any expungement case is look at when they were charged or convicted. Bless you. If they were convicted prior to 1989, there's a whole other section of the statute that addresses that. Convictions before 1989 are dealt with in the latter part of the statute and are treated differently. Now, you may not see many of those cases, but there are in fact cases where if you were charged with something for protesting during the civil, generally protesting a civil ordinance that was unjust in the civil rights era, and you were protesting segregation, essentially if you're protesting segregation, there's a provision in the statute to expunge those offenses.
But the 1989 part is really complicated. So for people with convictions post-1989, we're going to show you there's like a nice little list, and it makes it a little bit easier to figure out whether it's expungable. For 89, there's kind of a criteria. And so you really have to go through each level of criteria one by one for the conviction. And then we've been talking about just going directly to the DA and talking it through. Will you consider this falling under the criteria that is listed for pre-1989? But because the Tennessee statute, the criminal code changed, anything post-1989 is really easily enumerated under this statute, but anything before it, you have to fall under the criteria, and there are definitely things that there might be a debate about. And our thought is that our first step would be to go to the DA's office and talk to them about those charges in particular.
absolutely correct. So, again, Joy makes her PowerPoints much better than mine, and they're with an eye towards teaching. Mine are kind of a bit of a cheat sheet. The cost of expunging a charge, we've already discussed, but in general, if it's a dismissal, no true bill, arrest, and release, then it should be expunged without any cost to the person. Is
What's
that
the
correct?
only thing you want to know about dismissals that will keep you from expunging it?
Question.
What will be attached to the dismissal? What could be attached to a dismissal that could keep you from expunging it? Court costs. So if somebody still, and so many of our clients have to pay court costs, they have to pay the court costs before you can expunge it. We can debate about that, whether that makes sense, but that's the way the law is written right now. And so if they pay it right now, like today, then you can get it expunged immediately. But for some of our clients, paying, that $500 is not even an option.
And along those lines, that's kind of another practice pointer, especially if you're taking a pro bono case for someone who is indigent. Maybe their only income is Social Security, they're living with a friend, or they're lucky enough to be in some sort of government housing. In specific circumstances, I'm going to emphasize that again, specific circumstances, sometimes courts are able to waive or reduce court costs. There are also a variety of different payment plan mechanisms, but that's a case-by-case basis. Just because someone has court costs that may seem insurmountable, dig a little deeper. I had a client who has passed away, who was facing a terminal illness, and who was trying to clean up his record. And so we systematically approached it. We were able to get court costs waived. We provided evidence showing his illnesses, showing he had had 9 years without any other incident. So just to think outside the box.
And this has been, especially for dismissals, I could feel John, like his stare coming to the back of my head going, don't forget to say this. So Judge Cerny, Judge Emery, there definitely are judges in General Sessions Court who are waiving court costs more if you can do a good affidavit of indigency to show that somebody could not pay it. Now, it could be because Penny White, and a former Supreme Court justice, but she got a $7,000 court costs and fees waived so that we could expunge somebody's record. And so the problem is it takes some time to write the affidavit and to argue it. Yes, in particular, Judge Cerny is really sensitive to this issue, to the point where right now there's actually a bill that has been introduced that some of you on the tactile listserv might have seen, where the clerk, who's upset about losing those fees, is basically saying, if we're going to waive court costs, could we give community service or something else in lieu of the. I love some of your reactions that make me so happy. So yes, but so there is some even movement in different directions on that issue, but at least for right now, I think it's worth asking, because what's the worst that can happen? What we've seen is either reduced a little bit or it's entirely reduced. So.
Would that be on both causes, like the first court cost of the case that they were charged with, and then you also do an affidavit of indigency for the expungement cost?
I've not had any.
So the expungement cost is a different issue, and we have not seen people waiving those because they're statutorily defined. And so the court cost, the judge, based on other statutes, feel as if they have some leeway to make a decision to waive it. We are trying to craft a legal argument for why we should think about waiving expungement fees, because especially since they're so high. But right now we have, and there actually is a class action lawsuit that we started out in Nashville on that issue. But right now the only fees we're talking about are the ones that originate with the actual dismissal or conviction. Great question.
George, is that cost and fines?
We've been including both. So some judges like to make that distinction, Terry, which is that they want to make a difference between a fine, which they see as hard, or restitution you don't get waived, but that a fine, depending on what it is, we might have a shot at. The things that we have the best shot at are court costs. I say argue everything. And the more because some judges are even more specific about whether it's jail fees versus Public defender costs, but you can get a breakdown from the clerk's office to actually see how that client has a $500 court cost on a simple possession charge, which in my mind is so hard to understand. But there is a breakdown you can get so that you can even make the argument more nuanced.
Does restitution have to be paid before the
Yes, yes, because that's part of the criminal sentence.
And when we get to discussing expunging a conviction, we'll talk a little bit about how some courts and some district attorney's office, specifically Knoxville, will argue that the 5-year period does not even start until all court costs are paid. All right, so looking at Tennessee Code Annotated 4032-101 G1A, so now we're about halfway in there. Let's see. There is a list of felonies that are eligible for expungement. So at A, B, C, D, those felonies are not eligible for expungement, but there is a specific list of included felonies, felonies that are eligible for expungement. There is a subsequent list of misdemeanors that are not eligible for expungement. Now, in your materials, you have a flow chart. The flow chart is something that we created with the Knoxville Bar Association that takes you through the basics of intake when you're doing an expungement case. When it does not address convictions, and the reason that we haven't really focused on that is because also included in your materials is a great resource from the Tennessee District Attorney General's Conference. It is kind of a model outline for expunging convictions. It has listed there the felonies that are eligible as well as the misdemeanors that are not eligible.
So the flow chart's super beautiful and looks, this is my black and white version, but it starts and looks something like this. There's lots of arrows, there's stop signs. I just wanted you to know what it looked like. And then there's the conviction-specific cheat sheet that we had from the Public Defender's Office. And they're super helpful. The Public Defender's Conference is really helpful to answering specific questions, and they have a nice finger on what's happening throughout the state, since we're so not very specific. And then behind that is what you would file for a conviction position.
So that's all online, that's not.
That's all in the materials on, yeah, we didn't want to punch everything, but that's in the materials.
So this is a list of what convictions are generally not expungible. Now, if something is dismissed and they don't plead to something less than that, then it could be potentially expunged under that basis. But violation of a protective order, a misdemeanor conviction that is not expungible. Child abuse, failure to appear, stalking. So, looking at the statute again and pointing out you can expunge a conviction, but if it's pre-1989, there are a separate set of rules in the statute, and I've got a nice little citation there for you to tell you how to get there. Expunging drug fraud is a new, if I'm saying that correctly, is a new subdivision in the statute that provides for how this specific charge could be expunged. And this is where we kind of see the law tweak every couple of years with, depending on who wants what added or removed. It's oddly specific. If you were sentenced for 4 years or less after 1989, and if at least 10 years have elapsed since the completion of the sentence. So that's almost a whole nother subsection there in how that is addressed. But, all right, so let's go through this. We've got felony convictions that are eligible. We have A misdemeanors that are not eligible. And then we have the other odd circumstance. Now this is really an advantageous thing in Tennessee because you can have multiple convictions expunged. But wait, I thought you could only have one conviction expunged. Well, in Tennessee, if the conduct which occurred occurred contemporaneously at the same time, in the same location, the same continuous criminal episode with a single criminal intent, and all convictions can be eligible under this part.
So that's one conviction.
One conviction.
No.
So
The definition of one conviction is huge. Does that make sense, everyone? So remember I originally said, I mean, there's so many parts of the statute that are exactly like this, which it says one thing, but it really, you have to dig a little deeper. I said you can only have one conviction to get a conviction expunged. But the definition of one conviction includes multiple convictions that come and that are pled out or that you were found guilty of that come out of the same instance. So I have one bad day where I'm charged with assault, trespass, and simple possession, and I get convicted of all three of those things coming out of the, so I have 3 convictions now coming out of that same incident, right? It was all part of that same arrest, that same bust. All of those are considered one conviction for the purpose of the expungement statute.
Go ahead.
If a person burglarized a strip mall, it went through 5 stores with those, I know in federal court, those are 5 separate incidents.
I don't find the statute to be super clear about what to do. That's like we're litigating that.
That's an advocacy issue, and
I'm gonna say that's one
TA
continuous
specific.
event.
Yeah.
And
If it's my client,
all.
absolutely.
That's what I'm saying.
But I don't, you guys can read the statute and tell me if we could talk about it, but like, I don't think it's super clear about that type of incident, where it's not all in one spot, one time, one moment, but it's all part of it. What is a continuous?
By way of argument, if not a appeal to an actual authority, I did have a case where someone was charged with burglary, and they pled guilty to it, and I was frustrated, because I was like, maybe I should have done better as a juvenile. And then, right after he enters his plea, the police officer comes in with 23 more counts against him. And we argued, sorry, Your Honor, that's double jeopardy, he's already pled guilty. And we got away with that day, so. Maybe
That's
that'll.
the actual language, that's the actual language on there?
This should be the actual language.
So your argument's gonna have a tough time against the one location,
Yeah.
unless we say it's Knoxville. I'm willing to help anyone make those arguments.
Okay, so here are the basic requirements. So it's got to be on the inclusion list, e-felony, or not on the exclusion list, a misdemeanor. If it's a multiple convictions, it's all got to be in the same locus, same location. But there's more. There's more requirements. You must never have been convicted of any other criminal offense, any federal offense, any other state, including, though of course it doesn't include traffic offenses. At the time of the filing of the petition, at least 5 years must have elapsed since the completion of the sentence. And this is where Joy is having some interesting litigation addressing, does the court cost itself represent a civil judgment or a part of the sentence? Did I say that correctly? All right, I think I'll listen.
We have several clients that recently paid court costs, but the actual, their probation ended over 5 years ago. And so is the court cost portion of it, which is separately enumerated in the statute, actually a part of the criminal sentence. And I think it's an interesting, we have good argument. Done.
So let's push them last. All right, so the petitioner must complete all the requirements of the sentence: fines, restitution, court costs, any other assessments. If it's an alcohol and drug assessment, they must meet all conditions of supervised or unsupervised release. So if you're working on an expungement for someone and you're lucky enough that the same probation officer or probation office that handled their probation is still available, contact them and say, I need a very short letter that just says so-and-so has completed all requirements of probation and paid all costs and fees. I've included that as an exhibit. The problem, of course, is when it was state government, then it was outsourced, now it's state government again, and there's no one to contact. So you got to rely on court records. If so required by the sentence, if someone is required to remain free from alcohol abuse or dependency or any other controlled or prohibited substances for less than a year, that's just one common condition that the person would have to at least show proof that there's no proof that they didn't complete that. Any questions on that section? Okay. All right. We've got 2 more. These are kind of other areas of the law a little bit, but they're expungements or helpful to people who are looking to get an expungement. Juvenile expungement is something that you should try to do with every juvenile client you have. If you could diary out 2 years after they turn 18, you might be able to help them expunge their juvenile record. Now wait, a juvenile record is sealed. No one should have access to that. But you apply for certain schools. Actually, I remember applying for the Cecil C. Humphreys School of Law, and then great school, got accepted there, but I went to UT. But they asked to unseal your juvenile record, or at least they did when I was applying. So there are a lot of schools, programs, or other entities that will ask for a release to see your juvenile record. So just because you pled guilty or had something happen in juvenile court and it's sealed doesn't mean that it's expunged. It can still be accessed. For juvenile expungement, at least 1 year has to be removed from the person's most recent delinquent adjudication. So we're not talking about just a single conviction. There could be multiple, it seems. The person must never have been convicted of a criminal offense as an adult. So that's an important caveat. If they were charged with something in juvenile court and then transferred to adult criminal court, no juvenile expungement. They cannot have been convicted of a sexual offense as defined in Tennessee Code Annotated, whether in juvenile court or following transfers from juvenile court. Juveniles sending other juveniles inappropriate photos could be sexual exploitation of another juvenile. So there are definitely some things to think about legislatively and in advocacy regarding something that might be two kids doing something that they shouldn't be doing. How that could stay on their record for a lifetime, perhaps. It also doesn't cover an adjudication of delinquency for a violent sexual offense. And the individual has to have maintained a consistent, exemplary pattern of responsible, productive, and civic-minded conduct. Well, if you're in college or you're going to school, there's all kinds of great, easy information that you can include in a petition to demonstrate that type of thing. The other really great caveat here is they're doing great. And then we have something at the bottom that says they're doing amazingly better than they were before. Which for so many kids in the juvenile system is a realistic thing.
Yeah.
They're still struggling, but they have made such an incredible adjustment of circumstance that we think that the juvenile cohort can help them once more by expunging their record. So.
And for that
Right,
catch-all,
okay.
you may not have to wait the year. I've had Judge Irwin here expunge a record because I have a kid who wants to do military, he wants to go into the military, if you have something like that, he's really interested in expunging the record even before the year is up. So, look at the juvenile statute. It's much more detailed than you'd expect it to be. But that's one area that I wanted to just add to what Daniel was saying, is that so with less than a year, you may be able to get a juvenile record expunged with extraordinary circumstances shown and need. And then the second piece of it for favor of expungement, even though they're sealed, the DA's office and the federal court can see, so you know how you can get sentencing enhancement based on juvenile records. And so what I understand is that if they're expunged, even the DA's office doesn't see them. And so those extra little, 5 to 10 years your client might have to serve on sentencing because of a juvenile delinquency adjudication, it's a real serious thing.
Very true.
If the client was convicted of a criminal offense as an adult, and you get the conviction expunged, the adult conviction expunged, do you think this will work for the juvenile?
Oh, yeah, I actually think you could argue it.
Subsequent one. It depends on the language of the statute, which we have included on our materials, the juvenile expungement statute. But I don't recall anything that would say has not had anything else expunged. But it would really kind of depend, and would be an arguable issue where the court could say, well, they have been convicted of a criminal offense as an adult, but then you could cite the expungement statute and say, but they were restored to a status before that. I think it'd be tough. I'm not sure you can do it. If you give it a shot, though, give it a shot.
Testing the effectiveness of
Of the
expungement is
expungement.
what I'm
Yeah,
doing.
I like it.
Yeah.
I like it.
What about school records, UT records, like if you have an incident at UT, is that something that's a public record that doesn't necessarily go into the judicial system except for the university judicial system?
I think that you, under the Family Educational FERPA, Rights and Privacy Act,
Right.
you can request to amend your record,
Okay.
but I would guess that supplementing it with additional information
I know.
might be
Anne
the
Louise
best
is
way to
gonna
do
kill
it.
us.
Okay.
I'm so sorry. We tried to cut down a 2.5 hour into 45 minutes, and we've completely failed, which my students will tell you. But if you give us 2 more minutes, we'll present the last slides and then tell you what you have, because you do have something in front of you that's not in your packet that you'll want to know about.
And here's this slide real quick. A certificate of employability is a great new tool, new statute, new idea that an individual can apply for that basically provides a shield against allegations of negligent hiring for the employer. For instance, you have a theft charge. you want to work as a home health aide. You then apply for a certificate of eligibility, obtain that, then someone might be more willing to hire you with that prior charge on your record, and it kind of protects it, promotes employers doing
So
the
for
same.
people who can't get expungements, think about looking at the certificate of employability statute. So what do you have in front of you that I think is really important for you to know? John and I were actually going to run through an exercise that we can't do to have you actually fill out a petition. So what you have in front of you is something that looks, you should have this, what else, John? What else do I have? You should have 4 different things. You should have, do we have a cheat sheet? Do we have that out yet? Yeah. Do we even give them the cheat sheet already? Oh, no, it's here. Okay. So, here's why this is important. If you go to Knox County to do dismissals, which are like 90% of the things that we do in expungement clinic, Knox County has a screening twice a week. If you go there with your stuff ready to go, they'll just take it and process it. But if you want, the important thing to know about expunging dismissals right now in Knox County is they've actually created a different sheet and form than online. So you know how you can go online and get your criminal history printed out? Oftentimes it doesn't have enough information for you to then fill out an expungement petition. When they started doing the screening, they realized that. So they have, it's not accessible online, it's only accessible at the screening, but if you go to the screening, give your client's name, social security number, and date of birth, they will print this out to you. Or if you email this Dana in the clerk's office, she'll send it to you in advance. So the example that you have in front of you is this. This is what, and if you look, it's the GIMS, it's the Justice Information Management System, but if you look really hard, it says GS Expungement Summary Information. This is the expungement specific form. Everything you need to file for an expungement is on this form, except for a couple things. That's when you have to go to your, so this is what you're gonna fill out, right? That you're gonna fill out a petition that looks like this. Sample petition you can get online, we have it in our materials.
These are for dismissals only.
For dismissals.
There's a different process for convictions.
For convictions, you have those materials in your packet. The things that are not on that GIMS printout are the sex of your client, the date of birth of your client, the social things you can ask your client for, race, okay? But everything else you need, the charging document, everything else you need will be on that sheet. And we were gonna have you guys do it and talk to us about it, but we gave you a cheat sheet for James Bond and his reckless driving charge, so you can see how you would translate that GIM sheet into the actual petition for expungement. Once you do it 3 times, it's like a no-brainer. But for pro se folks who are going down and for people who need to do this, understanding how this thing that they give you translates into this, it's like Greek. And so if you try it, if you work with the one we gave you and try it once and then compare it to the sample that we've written out for you, you'll get it. And for a lawyer, it's not a problem at all. The only additional thing to mention that's not on even the DA's cheat sheet, you gotta know, you only know if you go there, is that there are attachments, and no one ever knows which number 22. No one ever knows where to put the attachments on the petition, and our cheat sheet will show you where to put the attachments. Okay? Well, I hope this is useful. You have my business card. I am not kidding. I'm so sorry, Ann Louise. She's going to kill me. But if you need anything, email us directly, and either one of my students or I will get back to you and help. Thank you guys so much.